Hello, my name is Julie Dorr, and I wanted to introduce you to our webinar today, Making Good Hiring Decisions, Pre-Placement Actions to Reduce Your Risk and Create a Strong Workforce. Again, my name is Julie Dorr, and I will be your moderator for today's event. Our presentation will last approximately 40 minutes, with the remaining time available for your questions. Earlier this morning, we emailed you a link to our presentation that you could download and have available if you'd like to take notes. If you haven't received that, feel free to email me at my address is julie@enlighten, and I've got it here on the screen right now, julie@enlightenbiz.com, and I'll be happy to send that to you right away. Also note before we get started that this webinar and all of the accompanying materials are protected by copyright, and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with legal counsel to address your specific situation. So before we get started, I'd like to introduce our panel of experts. We first have attorney Marla Merhab Robinson. Marla is with the law firm Merhab Robinson & Jackson, where she is a partner and head of the firm's Transactional Department. She primarily practices in the areas corporate, mergers and acquisitions, real estate, finance, and employment law. Our second panelist is Tim Santoni, and Tim is actually, let me get to Tim real quick, is the president and CEO of Santoni Investigations, based in Orange County and with offices and partners throughout the world. Tim provides clients with support in insurance defense, employment backgrounds and screenings, digital forensics, and a number of other investigative services. They now have online screening platforms that you can order and monitor background checks 24/7. And then I have Linda Duffy, president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. Now, I'm going to turn it over to Marla today because we are going to get started right away on the agenda. We have a very information-packed webinar today. So, Marla, if you'd like to get started.
Thank you, Julie. So today we're going to talk about reducing risk and creating a strong workforce. I'd like to identify, as we look at our agenda, two types of risks that we're talking about. One is legal risks, which is what I will address, and that's when we'll speak to the FEHA and ADA considerations in hiring. And the second is the risk of having a lousy employee, which comes with all sorts of other risks of what that employee might do while employed, if the turnover, if they leave. I'm going to be identifying risks associated with the law, and that is the number one risk, that it is illegal to discriminate against job applicants because of a known or perceived disability. Then I'll look at medical exams, drug testing, and the risks associated with those, and looking a little bit at the benefits, and then some other assessments that are being used by employers. Tim will then be talking about best practices on background checks, and Linda will be speaking to reference checks and new hire documentation to help lower that legal risk. So as I said, the first and greatest risk, you'll hear me say maybe more than once today, is the risk of claims of discrimination because of a known or perceived disability. This law comes from two places, from the state law, from the Fair Employment and Housing Act, and from the federal law, the Americans with Disabilities Act. The California Fair Employment and Housing Act is far broader than the Americans with Disabilities Act, and as you can see from this slide, it applies to employers of 5 or more employees, while the ADA is only 15. However, throughout this conversation, you can just assume if you're here in California, you should be complying with the FEHA because it is broader, and that means that's the requirement. The ADA is enforced by the EEOC, the Equal Employment Opportunity Commission, and FEHA is enforced by the Fair Employment and Housing Commission. To qualify as a disability under FEHA, an impairment need only limit and not substantially limit a major life activity. ADA it requires that the disability substantially limit. So you can see that that's where FEHA is much broader in the protections for the applicant and the employee. And by the way, just as an aside, we are speaking today about applications or applicants and hiring, but these laws do apply to current employees as well. So both FEHA and the ADA require reasonable accommodation for applicants, and as I just said, also for employees that are current employees. So the question becomes, what is reasonable? And we have to remember that what is reasonable for Coca-Cola may not necessarily be reasonable for you as an employer, and that's because of your size, your gross revenues, your resources. This term reasonable is one of the reasons this is what I consider one of the greatest risks in hiring. Plaintiffs' lawyers, the attorneys that represent employees, love these cases because we don't have a definition of what is reasonable. It's on a case-by-case basis. Here we've got some bullet points to give you a little bit of help. You can't refuse to consider an applicant because he or she requires a reasonable accommodation to perform a job. But again, we don't know what the definition of reasonable is. We have to look at each particular circumstance. And this is one of those areas where I would encourage you to get assistance from counsel, because counsel can help you identify what might be considered more reasonable or unreasonable, never with a sure final opinion, this is going to be reasonable or unreasonable, because it's a question of fact for a judge or a jury. Both ADA and FEHA require an interactive process to determine whether an accommodation is needed. But as you're going to see, you can't start that process until you know whether or not there is a disability. If you're considering hiring, you might look to the ADA General Hiring Guidelines, which can be found on the ADA website. We've put them here on the next slide as well. But just to give some examples of some accommodations, designating parking spaces for persons with disabilities that are closer to the entrance. Now, is that reasonable? Maybe, maybe not. Now I can give you an example when it's not reasonable. Sometimes the employer has to pay for those parking spaces if they're with a landlord with a lease that requires payment. That might be an undue burden on the employer depending on the cost of that. So we look at costs as whether or not there's an undue burden. Ramps being added, guardrails, handrails, increasing door size to accommodate people using wheelchairs. Doors that are easy to open. You've seen doors where you have the push instead of the pull, with just not a knob, but just a button. Accessible elevators. Some of these things we're talking about could be considerable expenses. Signage, emergency warning systems that are both audible and visual. So we look at each situation on a case-by-case basis. That's why it's very factually inquisitive, and each instance is different, and that's, again, where we recommend that you check with counsel. Another area where we see both the potential risk of disability discrimination and other violations of law is in pre-employment inquiries. And we've provided you an attachment to, I don't think it's on the slide, I think it's an attachment to the PowerPoint presentation with the questions that are acceptable to ask in interviews and those that are unacceptable.
Marla, I'm sorry for interrupting. Are we on the general hiring guidelines slide? I'm sorry.
We're on the next slide.
Okay, my apologies, folks.
It's not changing?
Pre-employment inquiries?
Yes.
Okay.
So I think we were providing this as an attachment. If you can go to the next slide.
Got it. Okay.
But to the question of the inquiries, you're prohibited from asking questions which are disability-related questions. A disability-related question is one that is likely to elicit information about a disability. For example, you can't ask, do you need accommodation to perform this job, or can you perform this job without accommodation? And I will tell you, I've unfortunately seen some job application forms where those questions are on there. So you need to be very careful about the application forms. Linda's going to talk a little bit more about documentation. You want to be limiting the inquiries to whether or not the person can perform the job and is qualified for the job. So there is a very narrow exception to when you can ask about a need for reasonable accommodation. And that is, obviously if somebody is already in a wheelchair or on crutches, has a disability that's apparent, or if someone voluntarily tells you about their disability. I've had many employers call me and say, somebody volunteered that they had diabetes or another known disability. At that time, then you can ask about reasonable accommodation. Now, what about medical exams? A medical exam, first we must determine whether or not it is a medical exam, because there are things that are not medical exams that people believe are. And the best example I can give you is a physical agility test. Police officers often have to take physical agility tests, such as going through an obstacle course. That is not a medical exam. Okay, a medical exam is a procedure or test that seeks information about the individual's physical or mental impairments or health. And it's important that it's both physical or mental. And an exam must be administered by a healthcare professional or someone trained by a healthcare professional, and the results are reviewed by that same healthcare professional. We look to whether or not it's done by a doctor or a doctor's assistant or a nurse, that type of thing, whether or not there's medical equipment being used. A medical exam should only be requested and conducted after an offer of employment has been made. I think most HR professionals know that, but I don't know if they know the reason. And the reason is, again, you're protecting from knowledge of a disability, where you might be making a decision based on knowledge that you aren't supposed to have. And again, it should be done non-discriminatorily to all employees in a particular category. It doesn't mean you have to test or provide a medical examination for all employees just in the same category. So you might not have medical examinations for your office people, but you might have it for everyone in the warehouse. And then the medical information must be kept confidentially. It should be a separate file, not in the same personnel file, because it's limited in who it's exposed to. So in post-op medical exams, there's two standards for these, for conducting them. There's the FEHA standard and the ADA standard. Again, FEHA provides more protection to the employee, so that is the standard that you must follow here in California. And that requires that the medical examination or inquiry be job-related. And the best example I can give you here is if you have a secretary who is going to be sitting at a desk all day typing, you can't require a medical exam that sends her to the doctor to test whether or not she can lift 20 pounds. It's not a necessity of the job. It's not one of the essential job functions. So it has to be job-related. And you'll see when we get into the job functions in the next slide that that's how you determine whether or not it's job-related. If a question or exam screens out an individual because of a disability, the employer must demonstrate that the reason for the rejection is job-related and consistent with business necessity. So let's talk about the essential job functions. The California amended disability regulations in FEHA that just came out earlier this year make the essential job functions and drafting the essential job functions a requirement. So here it says use job descriptions or a separate list of essential job functions. That's a typo on our part. You should always have separate lists of essential job functions because of these new regulations. Whether or not you use job descriptions or not is up to you. I believe that essential job functions and job descriptions are your best defense to claims of discrimination and other claims in both the hiring process and also the termination process, which we've talked about before. Let me just give an example of the difference between essential job functions and job description. If you have a salesperson, an essential job function of a particular salesperson might be that he or she can travel 2 or 3 hours on a plane a day because they're required to go visit customers. That would be an essential job function. Is that something that they can handle physically, traveling and maybe even carrying equipment? Part of the job description might be, as a salesperson, you are required to gross sales, make sales of $10 million a year. That's the difference. One, again, the essential job functions, I believe in most of the attorneys who are interpreting the new amended disability regulations, is a requirement now, and job descriptions are not. Although, again, we use both as defenses in litigation all the time. So we've given you some examples of essential job functions here. There are other factors to consider in determining if a function is essential, basically including whether the reason the position exists is to perform the function, the number of other employees available to perform that function, or among the performance of the function can be distributed, among whom the employees, and the degree of expertise or skill required to perform the function. this is another slide on confidentiality of medical information. We spoke about it a little bit earlier, but the exceptions to confidentiality are the supervisors and managers may be told necessary restrictions. Again, this is all about what's necessary to be released. It can be given to and used by the appropriate decision makers involved in the hiring process so they can make employment decisions. They need to make them consistent with the ADA and FEHA. But what you really want to put in your mind here is a need-to-know basis. Does this person need to know? Obviously, government officials, investigating, first aid, and safety personnel. And you can always give the information to workers' comp offices or carriers. You can use the medical information to determine reasonable accommodations for the individual, but it's not the medical information alone which is going to determine that. As I said before, it's all the facts. I'm not Dell Computer. I'm the law offices of Merhab Robinson and Jackson. What's reasonable for me is not going to be the same as what might be reasonable for Dell. And there are other factors, not just size. I don't want to mislead you. Not just the size of the employer, but maybe the location of the employer, what work the employer does, whether it's safe and not safe, is it office, is it manufacturing. So it's all of those factors. The ADA and FEHA do not protect individuals who currently use drugs. I think most people know that. However, they both do protect those who are former abusers. Sometimes it's difficult to tell. So California law does allow drug testing pre-employment and post-employment. It does come with some risks, which we'll talk about later. But the most important thing to me is to determine why you're testing and whether you should continue testing. I have clients, for example, private schools. It's very important that they test. Some government contractors are required to test. Department of Transportation employers are required by law to test, and they test everyone for everything. I had a client who was testing for everything, a computer company, and the owner of the company called me and said, Marla, I've got this applicant who is outstanding. I know him from prior businesses. I really want to hire him, but he tested positive for marijuana. So my response was, well, if you don't care if he tested positive for marijuana, why are you testing for marijuana? Don't test for it. You won't know if he's positive for marijuana. Now, that's not to suggest he shouldn't watch for drug use in the workplace, especially if there's safety issues. I have a HR director, dear friend, who worked at a manufacturing company, and the principals there said, we don't really care about these people who tested positive for marijuana. Let's just counsel them. I'm not smoking marijuana before they come to work or at work. And what happened there was they had an employee who came to work stoned, and when they approached him about it, he said, well, you knew I was a marijuana smoker. That you've got the employee now using that information against the employer. I would suggest that would have been much worse since it was a manufacturing company, had the employee gotten hurt. The employer really would have had a problem. So be sure you know why you're testing, because, again, it does come with some risk. And on the next slide, we'll address some of the risks. There's the risk of defamation. You know, if the employer publicly produces the results of the test or expresses the results of the test, and that, of course, with social media, these things are getting out when they shouldn't. The most common claim is invasion of privacy. Sometimes the testing procedure is wrong. You know, the applicant or the employee, again, this works for both, is asked to disrobe in front of someone or go to the bathroom in front of somebody. So those issues. There's also just general California Constitution rights to privacy issues. However, California has upheld private employer testing. But it has a greater likelihood of being held valid if it's conducted in a manner that respects the dignity of the applicant and or employee and uses reliable and updated techniques. Always a licensed facility should be doing the tests. I've had a lot of employers call me recently regarding the medical marijuana cards. Well, I've got an employee who comes in and tells me I've got a medical marijuana card. I should be okay, right? No. You as an employer, you are not required to accept the medical marijuana card. You can still discipline up to termination an employee who has a medical marijuana card and tests positive. And again, you don't need to hire an applicant who tests positive. So other assessments. There are other assessments such as psychological testing. Psychological testing is rarely allowed in California after 1991. There are some limited exceptions. This is an area, again, I would encourage you to consult counsel. There's behavioral interviews. I really like behavioral interviews. It's just questions about how would you react in this situation? What's your behavior in this situation? For example, what would you do if you had an employee who was found stealing? You know, I think really good recruiters are good at asking those behavioral interviews. There's behavioral assessments. There's tests and tools to indicate how someone might react and without asking them. With all of these, you just need to ask, how accurate is it? What does it measure? What's the impact on the candidate? Does it protect your company from legal risk? And can you measure the ROI, or is what I would define as, is it working? Is it working for you? Do you have increased turnover? Do you have decreased turnover? We've been using this test more or less for 3 years. I hear employers will say, we've been using this assessment for 3 years. Well, how's it been the last 3 years? Have you had better retention in the last 3 years than you've had before? Worse? The same? Really need to look at what you're trying to achieve by using the assessment. And again, the people who are using the assessment should be trained in the assessment, properly trained in the assessment. Question whether or not the assessment has scientific foundation, how it's validated, how it's been validated by others, and how it be validated by you. So now I think my time is up. I'm going to turn it over to Tim, and he's going to speak to background checks.
Thanks, Marla. Appreciate that. I'm going to talk a little bit about background checks and how they can be used effectively and go over some information on common misconceptions and all their recent laws as it affects credit checks. So first off, compliant applications, forms, and disclosures are key, especially the fact that we're in California and things are changing quite constantly. So authorization forms, disclosures, pre-adverse and adverse action forms need to be up to date, and they also can vary state to state depending on where the employer is based as well as where the employees are. It's very important that those updated versions are kept, maintained, and used, as they can create liability if an employee is able to find a loophole in that and obtain counsel. As far as obtaining accurate documentation, by utilizing electronic forms and electronic applications, employers can eliminate data entry errors that can lead to false information being reported and background checks having to be rerun, costing more time and expense. Most importantly, by using the electronic forms and applications, the employers and HR professionals don't have to spend their valuable time sending, receiving, forwarding those documents or entering data into multiple systems, which in effect saves them a tremendous amount of time and speeds up the background screening process, which is key in bringing on talent and making good decisions. We recommend that clients should work with their team and or our firm to set up background screening packages that align with their business goals, their practices, and are geared toward the positions they hire for regularly. This allows them to order quickly, decipher the information provided, and report quickly back to a manager and or make a decision on that particular employee. Planning ahead obviously is a given, but accurate information is key in making those decisions. So when employers establish a background screening process, have established systems and packages, it's easier to order, anticipate any roadblocks that could come up based on the information that they need or could arise, and allow ample time to obtain that verified information to make that decision. One other key aspect is that many employers conduct background checks on employees at the time they're hired, but they never follow up and recheck them on a regular basis. In fact, surveys suggest that 80% of employers conduct some sort of background check on their employees, but less than 40% recheck. We suggest that employers document their new hires in their handbooks and check to make sure that the employees understand that there are policies in place that clearly states that random and or regular background checks is a standard practice so they can avoid liability. We encourage you to check with your employment law firms or HR consultants to make sure that that applies. Another fact that can happen and that allows employers to check things in the background would be any employer that employs drivers should enroll with the DMV's Employer Pull Notice Program. It allows employers to be notified if any of the following are reported on their driving record. It includes convictions, failures to appear, accidents, license suspensions or revocations, and any other actions that are taken against driving privileges. Now we're going to move on to typical components of a background check. Many of these things are very common, but I just want to elaborate on a couple of the key pieces. As far as the Social Security trace goes, we conduct those to develop aliases used by the applicant so that those names can be searched as well for those criminal records that may apply. The social trace is also used to verify and develop counties of residence that are either reported or not reported by the applicant on any forms or documents. And also the SSN provides the date when the social was issued, the state in which it was issued, and whether or not the person the social was issued to is deceased, which can be useful for a variety of reasons in that process. As far as criminal searches go, a national criminal search is an effective way to blanket the available courts for criminal records in an electronic fashion. I want to point out that not all courts are searchable via electronic methods, and thus a true national criminal search is not possible. That's why we supplement with county-level courthouse research, which is the most accurate and reliable search in the counties where the person has either resided or been employed. Further, county records must be searched and are reviewed to verify convictions and charges for reporting, and are in essence the key piece to the system. Of course, sex offender registry searches and driving records, as well as federal criminal, can be very useful. And we'll get into credit checks when applicable on the next slide. We also want to point out there's industry-specific databases, specifically in healthcare and retail, where searches can reveal offenses directly related to crimes that may be missed in searching other databases, like criminal or other court-type searches. When it comes to verifications, statistics suggest that over 53% of applicants lie on their resume, while more than 80% provide information on resumes that is misleading. Failure to verify degrees in previous employment can prove to be costly. A great example of this would be the former Yahoo CEO, Scott Thompson, who lied about his education on his resume. And the estimates suggest that this cost Yahoo over $7 million, which is no small matter. Now I want to take a look at credit checks. As many of you may know, legislation was passed this year that clearly outlines when running a credit check is permissible as part of an employment background check. The new guidelines, as indicated on this slide, are very specific and should not be taken lightly. I also wanted to dispel a myth about in the industry about background checks, which is that credit scores, commonly known as a FICO score, are not revealed by the credit bureaus when an employment credit report is conducted, even if it is permissible under those new guidelines. So we encourage employers to have a strategy around what the credit check will be utilized for and how it can be read and used to make a decision about that particular applicant should their position fall into one of these categories. Additionally, we encourage employers and managers to consult with HR professionals and or their attorney to properly identify the position they're hiring for so that they can determine whether or not running a credit check is even an option. Now we're going to move on to how backgrounds can improve business. First off, we want to look at reducing risk. The U.S. Chamber of Commerce estimates that theft by employees costs American companies $20 to $40 billion every year, and to pay for it, every man and woman working in America today contributes more than $400 per year. The Chamber also reports that an employee is 15 times more likely than a non-employee to steal from an employer. Unfortunately, 75% of employee-related crimes go unnoticed. We also indicate that having a system in place of screening will obviously discourage applicants with criminal histories, because they'll understand that those will be picked up on. Insurance costs are a hot button in these times with regard to employers, and often workers' compensation carriers will ask employers if they conduct background checks on employees and take this into consideration when underwriting policies. Additionally, we found that some insurance companies will require that employers conduct background checks on their employees if they begin to see repeated claims resulting from what they believe to be employee theft. Workplace violence is also another key piece that background checks can have an effect on. And according to studies that we've seen published by the Society for Human Resource Management, workplace violence can cause the following issues: decrease in morale, perceived decrease in safety, less trust amongst coworkers, increased levels of stress and depression among workers. We believe that employers can use background checks as one of their pieces, one piece of the plan to actually reduce violence in that workplace. And now I'm going to turn things over to Linda.
Tim, thanks so much. We really appreciate you joining us today. Something, Tim is very, I guess, humble is the word I would use when he describes his services, and so I just wanted to put in a little plug for Tim. Tim's a full-service security agency, investigation agency, so he does a lot of things, as we sort of mentioned on his bio slide. But one of the things to understand about his background checks is not only does he have the online platform where people can sort of self-administer and take care of all of the administrative parts really easily and seamlessly, but because they do have feet on the street, they will go into different counties and pull records by hand if they need to. You can also pick up the phone and call his people to actually get answers to questions about what shows up on those background checks. That's where I think he really adds a lot of value that he's very humble about sharing with everybody else. So having said that, I want to just move on and say, in addition to doing the background checks and drug tests and maybe other assessments and everything else we already talked about, there's always a question of reference checks. And I'm going to give you sort of my split personality opinion on this. Part of me believes that these are a complete waste of time, to be honest with you, because if a candidate gives you a list of people and says, hey, call these people, I gotta say they'd have to be pretty stupid to give you people who are going to talk badly about them, right? And a lot of times when you call a company, you're going to get just name, rank, and serial number type answers. And so there's a part of me that does believe that. Having said that, I think there's a few different ways you can sort of get around that. And it's important to be able to develop appropriate questions that are going to elicit the type of information you want. But when we do reference checks, which we do on candidates before we refer them on to our clients when we're doing a search for them, we're always going to try to get sort of a 360-degree view of that candidate. So we're going to get not just the references they want us to have, but we're going to ask them for prior bosses, peers, direct reports. So we can sort of get that 360 and figure out, okay, so what are they like as a boss if they have people reporting to them? What do their employees say about them? How do they like working with them? What do their peers say? And find out as much information as possible. If they give me a list with 5 or 6 names, I never start with the one on top because that's going to be their favorite person. I may start at the bottom and work my way backwards. Because I'm just, again, trying to get the true picture of what's going on. A lot of times also I'll ask for additional references, or I'll ask the people I'm talking to, who else should I talk to, right? Who else knows this candidate, and try to get like sort of a step removed from the list that I was provided by the candidate. Another great source is LinkedIn recommendations, because again, it can be staged. There's no two ways about that, but we know at least, as opposed to a letter that's handed to you with a letterhead that has this glowing recommendation, we don't know, did the candidate walk out with that letterhead? How did that letter come to be? But I know if it's on LinkedIn, they would have to go through a whole bunch of steps to create a false profile for somebody in order to write themselves a recommendation. So I have to believe that if I read it on LinkedIn, at least it has, I'm going to say, a higher degree of truth, at least, in my opinion. Another thing about reference checks is just be careful if the candidate's still employed. You always want to make sure that you're not burning a bridge, prematurely or unnecessarily. So if they're employed, sometimes it's okay. Maybe they've been told that they're, the position's going away, and so the current company is working with them, and they can, they can freely look for a job. But if not, you obviously want to respect that and make sure that you don't get them in any sort of trouble. With regard to doing reference checks. Okay, let's talk about the required documents. A lot of times my clients will say, yeah, I gave them a W-4 and an I-9. Isn't that all I need? And the answer is, nope, not even close. So there are, I think, 9 documents listed on this page. Some of these are probably really familiar to you, and some of them, I could tell you that if you gave most HR professionals a test, they wouldn't even get all of these right without looking it up. The W-4 is really clear. Obviously, everybody gets that for withholding at the federal level. The DE 2320 is a little blue booklet. You can also print it out off the website, EDD's website. If you just Google DE 2320, you'll find it. Same thing with the 2511 pamphlet. It's on paid family leave. The DFEH 185 is a little pamphlet. Again, you can print it out. It's just double-sided, or you can order them online. And it's the anti-harassment pamphlet that has to be given to all employees at time of hire. I'm going to skip over the I-9 form and come back to it in a second. The next one is based on Labor Code Section 2810.5, which was originally the Wage Theft Protection Act. This went into effect January 1st of 2012, so hopefully everybody is using this. And there's a form, again, you can download a template, but it's a notice to employee, and it has to be given to all non-exempt employees under that act. And so it has information about how people are paid, what's their base rate, their overtime rate, their double time rate, workers' comp information, ownership of the company, a whole bunch of information on it. And it also has to be given to them any time that information changes. Okay, so it's not just a one-time notice that you give people when you hire them. But hopefully everybody is using that form at this point. The employee notification of earned income tax credit isn't actually a requirement at the time you're hired. It is a requirement to be given annually at the time you provide the W-2 notices. And so you want to make sure there's just a paragraph, basically, that you have to let people know that they may have the ability to qualify for a tax credit. There's a time of hire pamphlet regarding workers' compensation. You're required by law to tell everybody about your workers' comp benefits, and there is a generic pamphlet that you can download off the website, and then you can fill it in, or go to your workers' comp insurance broker or carrier, and they probably have one already been customized for you that you can give out to your employees. And then, of course, we recommend that you always include an acknowledgement for those pamphlets, because those are things you're actually going to give the employees, and they're going to walk away with them. So you want receipt and acknowledgement that you can put in their file that you actually provided them with those documents. Now, going back up to the I-9 form for a second, hopefully everybody's heard by now, but I know some people have not, that there is a new I-9 form that's in effect right now. You're still in a grace period, but it is required that you use this new I-9 form beginning May 7th. Okay, so you just have a couple of weeks to get that in place. You can go to, I provided you with a link right there, so you can go to the government website and download it. It shows up as like a 9-page form because they have instructions and all sorts of other stuff. You want to make sure that you always provide the employee not just the form, but the list of acceptable documents. So you'll think about your current I-9 forms that you're using. There's a list where they can take anything out of column A, like a passport, for example, that provides both their eligibility to work in the United States and their identity, or they can give you something out of column B and column C. So you want to just make sure you always provide all of those, and you don't just tell the employee, hey, I need your passport, or I need your driver's license and birth certificate, or I need your driver's license and social security card. You must give them their options and let them give you the documents that will comply. I have to say also, I've done a lot of I-9 audits since starting my business, and I have yet to go into a company that has these forms filled out correctly. So if you're not absolutely confident about your ability to follow those instructions and fill them out correctly, I would urge you to have us or somebody else come in and audit those forms. So there's a lot of penalties if you just don't dot your I's and cross your T's correctly. In addition to the required documents, we have a list of recommended documents that you give your new employees when they come on board. The DE-4 form is sort of the California equivalent to the W-4 form. It's not required except under a few circumstances having to do with whether or not you have like a dual income household and some other things. But essentially the short version is if you have an employee that wants to have different withholdings for their state income tax versus their federal, this is how they would do it. They would fill out this form and get the different withholdings. So you want to just make sure that you have those available, and you can download that form off of the website as well, off the EDD website. Employment application. It's always really important that you collect all of their background information, not just what they want you to say on the resume, but also because I'm going to tell you in a second about the at-will language you need to put on that form. And you want them to basically, state and sign their name to say, hey, everything I've provided here in this information is true and correct, and acknowledge that if it's not, that you can fire them. And you don't have that information, or you don't have that signature on a resume. So it's really important that you get it someplace else, in my opinion, and so we've constructed our application for employment that way. An arbitration agreement, Marla, you should probably have some experience on this, but an arbitration agreement is usually a good idea just to make sure that you don't end up in court on every little thing that happens. And then really important is a proprietary information agreement to protect trade secrets. So hopefully you have those agreements in place, and if not, Marla and I can help you construct those. Then an offer letter, again, really key. I can't tell you the number of times there's confusion about how somebody's getting paid. There's promises that employees believe they were made. And I said, well, where's the offer letter? And they said, oh, we didn't use one. And I don't understand some people's reluctance to put everything in writing because to me it just adds clarity to the employment relationship up front. And again, as we're going to discuss in a second, it's an ideal place to put in the at-will language that you're going to want to protect yourself. And then finally, for those of you that are 100 employees or more in your company, you also have a responsibility to file the EEO-1 report every year. And so you need to collect that information regarding people's self-identified race, veteran status, things like that. And so the data record is going to be another important document to use as well. So I mentioned at-will language a couple times here, and it's really the employer's best friend. There's a section of the Labor Code 2922 that basically says, hey, if we haven't specified for you, if we haven't specified any sort of specific term, it's going to be at will. And that essentially means that you can fire the person, they can resign, other than for discriminatory reasons or other illegal reasons, anytime that you want to. Now, you want to make sure that you include this language, and I'm going to show you the language in a second, but that you include that language in applications, like I mentioned, where they're going to sign to it right up front before they even start working for you, in offer letters, again, and then, of course, have that at-will statement in your handbook. And you also want to make sure that you avoid anything that's contradictory to that. So having a phrase like probationary period, for example. I've got a lot of clients that say, well, I have a probationary period, or even an introductory period. I'm moving away from those in my handbooks I draft for clients because tell me what's special about day 91 versus day 89 versus day 90. Really, there's no difference. If I want to represent to my employees, hey, this is at will, you can come and go anytime you want to, and I can let you go anytime I want to. I don't want to then turn around and say, hey, there's something magical about day 90. So we do use introductory period tied to benefit starting point sometimes, but in general, you just want to be really careful that you're not contradicting your at-will language with anything else that you say. Now, the at-will language itself, a couple things that I highlighted on this next slide is that you want to not just cover termination of employment. That's usually how we think about it, but we also want to think about it in terms of changing any sort of the employment terms and conditions. Julie, if you could move that slide forward, please. So I gave you some language here that we use, again, in our offer letters and our application form. And if you notice the first paragraph, back when, Julie, the first paragraph that has red highlight in the top paragraph where it says the company has the right to change your position, and then in parentheses, by way of promotion, demotion, or otherwise, you want to make sure that you put that language in your at-will language as well. So it's not just about we can fire you at any time or eliminate your position or anything like that, but we can change it as well. We want to move you to a different department. We want to promote you. We want to demote you. We want to, whatever it is we want to do, you want to make sure you're protecting yourself there. And then the second thing is you want to make sure that only the president or CEO or general manager, whoever your top dog is, that person has to agree to any change in writing. Now, having said that, just be really careful because I have some clients, and I'll tell you a quick story that I had a client come to me, this is a family-owned business, first-time CEO. He came to me and said, we want to lay this person off, and when we pulled the person's file and we took a look, he actually had written a letter, again, signed by the CEO of the company, guaranteeing permanent employment because he thought he was doing the right thing, trying to help this person out and securing housing. So he, in his, his greatest benefit, trying to help, coming from a place where he's trying to help his employee, really got himself into a lot of trouble because he guaranteed permanent employment and then turned around and said, I won't let this guy go. We don't need his services anymore, 9 months later. So you just got to be really careful, again, about anything outside of the at-will language, making sure that you don't get yourself in any trouble. Okay, so the last thing I want to just talk about real quickly is written commission contracts. There's a new law that went into effect January 1st of this year. Previously, this Labor Code Section 2751 required that if you had an out-of-state employer but doing business with California employees, then you had to put any sort of commission contract in writing. The new law basically says that everybody has to do it, including employers based in California.
It went back and it made some changes to the prior law, like eliminating the treble damages and things like that, but it's important to know that you need to do this. If you go to the next page, Julie, so this, what's now in effect is that there's this labor code section, and it basically says that if you have any sort of short-term, if you have any sort of commission plan, bonus plan that's tied to productivity or some other measurements in the company, that you need to put that in writing. They did exclude short-term productivity bonuses, like spiff, that type of thing, on the spot, hey, great job, here's a $25 gift card or something like that, and also bonus and profit sharing plans, unless, again, it's tied to a specific fixed percentage of sales or profit. So if you do have a profit sharing plan, hopefully you already have that in writing. But if you have any sort of commission plans for salespeople or any sort of bonus plans where you're actually measuring something, you're saying, okay, we're going to give you a percentage of, something, whatever it is, percentage of the profit, percentage of the revenue, percentage of anything like that. You want to make sure that you're putting that in writing. Unfortunately, the law was not very specific about what needs to be included, but it does require that the agreement be in writing and also signed by the employee and that all parties receive a copy. So you want to put something together, have the person sign it. I would tell them exactly, what's going to be, how it's going to be measured, when it's going to be paid. And really one of the important things is think through all of those what ifs, and specifically when commissions are earned, because you want to make sure that everybody's clear. If I sell you something, is it I get my commission based on as soon as I issue the, the PO gets issued, as soon as the product gets shipped or the service is delivered, or is it based on when, the company receives payment for that? So all of those things need to be thought through, and then you can put, hopefully, some clarity around that situation. And with that, I'm going to turn it back over to Julie, and we'll take some questions.
Well, thank you very much, panel. Linda, Tim, and Marla, thank you again for helping us take the necessary steps we need to make a great hire. That does conclude the presentation portion of our webinar today, and we have about roughly 10 minutes or so available for your questions. Let me go through real quickly how you would do that. On the right-hand side, there's a control panel that one of the little boxes says questions. You just click on that to expand at the plus sign, and you type in your question down below and hit the send button. And I will read those questions aloud for our panelists to respond to. So let's get started with some of the questions that we have. And Marla, I think this one probably fits best with your part of the presentation. And Jim wants to know, do essential job functions need to be included in job posts? You mentioned it needs to be in the job descriptions, but do they also need to be in the job post?
No, they don't need to be in the job post, and I didn't say they need to be in the job description. I said they are in addition to the job description, because it's my position after the new amended disability regulations that essential job functions, having those written down, is required by law. It is not required to have a job description. We certainly recommend it, but it's not required. So no, they don't need to be in the job post, although if there are some that are clear, like must be able to lift 20 pounds or more, it will weed out applicants that you don't want to talk to. And as you all know right now, if you're doing any hiring, and I hope you are, let's get 2013 going strong, there are lots and lots of applicants. The last job that we filled here at our firm, we didn't even get through all the applicant resumes that were submitted because there was just too many. We couldn't do it, and they were all so good. So do you need to? Is it legally required? No, but should you? Probably at least some of them that would weed out what you don't want to see.
Okay, good. Thank you. And Tim, this question's for you. It's from Ricardo. If you recheck one employee, do you need to recheck all the employees? I mean, do you set some kind of precedent if you're only rechecking one employee?
Yeah, that's a great question, and that's where it's kind of a legal question there, but depending on what your policies are in place, and you don't want to discriminate or single out certain employees, but my recommendation would be is that if you have certain employees that are doing certain necessary functions and you have their consent, that you should continue to recheck them on a regular basis.
Okay.
Can I add something to that?
Please do.
Yeah, Tim's absolutely right, and it's no different because I get this question all the time from employers. Can I do this for employee A without having to do it for everybody else? Yes, with some risk. The minute you do something for one and don't do it for everybody in that same category or group, you run the risk of a claim that You didn't do it for the rest because of some protected class, whatever it is, race, religion, gender, orientation. Pick any one of them. It can be done. You need to be able to explain why that person and only that person, was their suspicion, to Tim's area. You need, if it's a benefit with somebody who's a superior employee, seniority, great salesman, so we're singling this person out to do something good for them that we're not going to allow for others. So it's, yes, you can do it. It comes with some risk. Just briefly want to touch on one of the things that Tim said, and he did such an excellent job. Thank you, Tim, for joining us. Decreasing workplace violence with the background checks. Workplace violence is on the rise to a level I have never seen in my 25 years of practice. We are having to use off-duty armed police officers more and more for terminations based on risk of workplace violence, even with board of directors meetings. It's terrible. So this is an area that I do encourage background checks on. I really think we need to do it. You have a duty as an employer to maintain a safe work environment for all your employees.
Okay, great. Thank you. And this one probably is going to be a Tim and Marla type of question, too. Are workers' compensation background checks a good check to run on potential employees?
Well, we may have different opinions on that, so I'll let Tim go first. So we all do.
My take on that is that in the state of California, you run a risk by checking those. It is possible, but let me give a little bit of the mechanics of how that works. So in the state of California, workers' comp claims are usually handled by the WCAB. A WCAB index is indexed by Social Security number. You can run that search. It's by Social Security number only. Those claims that come up would be those that are litigated claims. So unlitigated workers' comp claims would not fall into that database. Also, if you have someone using someone else's Social Security number, you may get a false positive, meaning you have a hit on a workers' comp claim that pertains to that Social Security number, but the name match is different, and that could open a can of worms. I'll let Linda and Marla talk to you guys about how workers' compensation can or cannot be used in the process of hiring someone from a legal perspective.
Okay.
Well, it can't be used. You cannot ask an applicant about their workers' compensation claims, and you cannot make a decision to hire them based on whether or not they have filed a workers' compensation claim. So that's the concern I have about a background check that gives you that information. And I will be very candid with everyone. Linda and I have lots of conversations about these kind of issues because we're weird and we enjoy them. I really believe one of the next waves of lawsuits we're going to see is from plaintiffs' lawyers against employers who do background checks and find out information that they're not supposed to find out. For example, if you're doing a background check, you're going to find out if somebody's married. You're not allowed to ask them if they're married. Now, does that mean you shouldn't do background checks? Absolutely not. I just gave you a really good reason to do them. I'm a big proponent of workplace violence, that kind of thing. I think that's a huge, huge benefit to employers.
Okay. And Linda, did you want to weigh in?
I do want to weigh in. So, because I actually had this conversation recently with Tim and with Marla about this. You can find out a lot of information, and in fact, you'll see at our next one of our upcoming webinars, we're talking about social media, and this is the exact type of thing that comes up. I can go out and find a lot of information about people using social media. That doesn't mean I can use it. So I don't want to be put in a situation where I have to convince somebody that I didn't use it. So, Tim can go out and find out all sorts of things about people, right? He can put people under surveillance. He can do a whole bunch of things to find out information. But you're going to be forced sometimes to say, oh, I didn't use that in my decision. Now, having said that, what I will say is, you can get pretty creative, and there's always a quote-unquote more qualified candidate that's available. Wink, wink. So what you can do is, ask a lot of questions during the interview process. I mean, what I do instead of saying, hey, Tim, go find out if this person had a workers' comp injury before, because you don't know, maybe that person was injured but got run over by the drunk guy on the forklift, right? So it's not about the injury. Find out if this person is really attuned to following proper safety procedures. And a lot of times if you just start asking questions, so tell me what kind of safety training you received, what kind of safety precautions do you take on the job, tell me what you learned about safety in your last position. Ask just some open-ended questions about safety. You'd be surprised what people volunteer. And then once again, don't make your decision solely based on that. But if there's a more qualified candidate out there, more power to you.
Okay, good. Thank you. Linda, you've got the floor right now. Daniela has a question. You know the documents that you covered that were required documents, are those for the state of California only?
Yeah, those are for the state of California. Thanks, Daniel. I should have pointed that out. So we do have some clients in different states, and in fact, right now we're trying to help a client transition out of California and open up a new business in Florida. So I've been trying to research like crazy all of the documents. Some of those documents are required across the board, but most of those listed, like anything that starts with a DE or DFEH, those are state of California. So really, federally, for sure, you need the W-4, you need the I-9 form, those two without a doubt, and probably everything on that list. I have to sort of go back in my head right now, but everything in that list other than is probably state of California specific.
Okay, good. Thank you. And then Crystal has a question about I-9s, and I think this one probably goes to you, Linda. Do we have to have all current employees complete the new I-9 form?
No. You have to just incorporate the new I-9 form as you move forward. So you don't have to go back, if I understand that's what you're asking. You don't have to go back and have everybody recomplete a form just because a new form came out. So anybody hired after 1986, I'm assuming that means most of you here, should have a form on file someplace, and just make sure as new people come on board that they're completing this form as opposed to any old version.
Okay, good.
And on the topic of I-9, if I may jump in, this is Tim here, that our online screening platform has integration with I-9 compliance and E-Verify, so that on an ongoing basis, once Linda conducts the audit and you're up to speed, our system actually allows professionals to interface with the system, calendar things, and be notified of document dates and other periods that may lapse and cause liability. And as Linda pointed out, the penalties on that stuff are significant, and the federal government is auditing companies these days. So anything to speed along that process and help employers better maintain those things and stay on top of them is obviously a benefit.
Great.
Julie, can I add one thing before I know we need to close? Just to add one thing, because I don't remember Linda saying this. Please remember your I-9s need to be kept separate from your personnel files in a separate folder, because if someone comes in to see them and they see something else, they share information with the EEOC and other agencies, and you don't want that to happen. And the other thing is to reiterate Linda's point, employers make mistakes on these I-9s all the time. Get audited before the feds come in and audit you, because they are looking at these all the time now. It's just a nice additional source of revenue for them.
Well, unfortunately,
and kudos to Tim on his program.
Yeah, nice. Oh, it's nice to hear that there's something out there like that. Again, we want to thank all of you today for joining us. We just ran out of time here, and I know there's a number of questions. I will be forwarding those questions on to our speakers, but again, you have not only their bios and profiles in here, but I've also put up here Linda and Marla's email addresses, so you can certainly contact them directly if you want those questions answered. Again, on behalf of Tim Santoni with Santoni Investigations, Linda Duffy with Ethos Human Capital Solutions, and Marla Merhab Robinson with Merhab Robinson & Jackson, I'd like to thank all of you for joining us. We also have another webinar scheduled, and this is a hot topic, and I think something everyone should be tuning into. It's email, Facebook, and blogging in the workplace, the social media policies and things that you need to have in place so you don't get yourself in some legal hot water. Linda and Marla, again, will team up again to tackle that topic on May 23rd at 11. There's also a link in your handouts that you can register right away for that, so please, we hope to see you there and join us. We appreciate your time today and look forward to providing you with more useful information in the future. Does anybody, the panelists, have anything else they want to say before we conclude today?
No.
Nope.
Okay.
Thanks, everybody.
Thank you, and again, thanks for joining us today.